All right, so you got your license to practice law. They've turned you loose on real people. You can now sue people. And of course, that's what we do, or that's what litigators do, is we sue people, sue companies, sue people. And the question arises when you have a case, is a suit, an action, something that makes sense in your case? A couple of things to think about. Sometimes, depending on some factors that I'm going to discuss with you in a minute, contacting the other side before actually bringing an action can be beneficial to you and your client. What's the positive of it? It's obvious. Less time, less money. You can, if you have somebody on the other side that's reasonable, you can hopefully wrap up the case much quicker than you could if you bring a lawsuit. What is the downside to that? And it's something you really should give some thought to. A lot of lawyers, litigators will tell you they will never contact the other side first because it gives the impression that you're not willing to litigate, that you're looking to really settle, and that if push comes to shove, you're really not going to litigate. And that's a legitimate concern. And so if you're fresh out of law school and you have no track record, probably not a good idea. Now, on the other hand, if you're an experienced litigator, you've tried lots of cases, you have a reputation in the community as being a good litigator, that you have no problem litigating, sometimes you may use that as leverage. They know you, they know that if you can't resolve it, you will bring a suit and you will win. So the first thing I would caution you about when considering whether to reach out and talk to the other side is based on your position, your experience, your reputation, could this be construed as weakness? And I think if you don't have any experience, the answer to that probably always is yes. Now, there are certain situations in which you're not going to have any real choice here. You're going to, I mean, these are obvious, but you're going to have to bring a suit. That doesn't mean that you can't bring the suit and then make some contact. What are some of those possibilities? Well, if the statute of limitations is about to run, I mean, you just got to file it. Maybe your client needs a temporary restraining order. Something terrible is happening. You have to get in there and get that injunction. That's another one. Then maybe you have a case where there are multiple jurisdictions, multiple courts in different jurisdictions that have jurisdiction over your case, and there are other suits that are about to be brought. You may want to jump in your venue, in your jurisdiction, sue first, because a lot of the state laws, when these similar cases arise, a lot of the elements of who is going to actually get the case is who filed first. Maybe you have a concern about the preservation of evidence, and you're concerned with spoliation. You want to get that thing filed, and you want to get some kind of an understanding on the other side, or get some kind of an order that prevents any further spoliation of evidence. But even in those situations, if you have the right reputation, you can bring the suit, get on the phone with the attorney. If you're experienced, you probably know the opposing counsel and say, I want to give you the heads up. The statute was about to run. I filed the action, but I would like to talk. You can do that too. Now, before you jump into litigation, and before you bring a lawsuit, you really have to give a lot of thought, because once you're in, you're in. Once you've brought that lawsuit, it may be very difficult for you to withdraw. At the same time, you have to advise your clients. Lay people, unless they've been in litigation before, are really not accustomed to how long it takes, how expensive it can be, how much of their time and energy is going to be required. And if you just off the cuff say, we're going to sue these people, most laymen will say, okay, well, you're the lawyer, I guess we're going to sue. And then when they get into it and they find out the realities of litigation in this country, they may be very unhappy with you. So you have to lay it out. The expenses, even if it's a contingency, you have expenses. Now, a lot of times, most of the time, probably the lawyer is going to agree to front that. But if we lose, you tell your client, even though I fronted those expenses, it's not ethical for me to pay them for you, so you're going to have to reimburse me. So the client goes into the litigation with open eyes and knows a little bit more about litigation than he or she did the first time. The other thing about litigation that people should know before they jump into it is discovery. Right? Your client says, we're going to sue these guys, it's going to be great. Well, okay, you should understand that by bringing this lawsuit, now there will be discovery. And the other side will be able to, have discovery of you. And you'll be deposed, and you'll have to produce documents, etc. And maybe there's something there that they don't want revealed, and that's something you should explain to your clients. The other alternatives to a lawsuit would be mediation or arbitration. Mediation is non-binding. You have someone come in, both usually, one party is in one room, the other party is in the other room. The mediator is going back and forth and back and forth. I've used mediation a lot of times. And sometimes it can be very, very profitable. I remember a case that we had where the parties were really far apart. It was an employment discrimination case, and my client had been very much damaged. Our numbers were pretty big. Their number was pretty low. We decided to do mediation. Now, we were there all day. I think we got there at 9 in the morning, and we ended up signing some agreement probably around 6:30, 7 o'clock at night. But contrast that to like a week and a half, 2-week trial. No comparison whatsoever. They got very close to our number. My client was very happy, and we didn't have to go to a lengthy trial. Arbitration is something different. Arbitration can be binding. Okay, so that you present your case to the arbitrator. The arbitrator isn't going back and forth. The arbitrator is sort of like a jury, and you're bound by the arbitrator. There's an arbitration agreement. And you agree that whatever the arbitrator decides, the parties will be bound by it. Those are some alternatives to litigation. But these are some of the things you should keep in mind when considering whether you should bring suit.